Hi everybody, welcome back. Kongi Fachoi, indeed, into the year of the ox. Let's hope it's much better than the year of the rat was. Okay, well, in fact, it'd be nice to be able to see you in person. I believe that classes will be going back face-to-face in March, which means we should hopefully be able to meet again face-to-face when we do the revision courses. Okay, so today we shall be reviewing causation and then getting on to the defences to negligence, and that will just about take us out for tonight. I might have time right at the end to have an introductory look at private nuisance, but our main topic, if you like, tonight will be defences to negligence. We did have a quick look at the defence of Valentine last time, or consent, but we'll review that again and then we'll cover the other defences to negligence, namely illegality or exterpy causa, for those of you who like Latin expressions. And also the most important defence to negligence is contributory negligence. You know why, because the main function of tort law is compensation. And so if you have a total defence that succeeds, then the plaintiff gets no compensation, no damages. Whereas if contributory negligence applies, then the plaintiff will get some damages. Big question, of course, is how much? How much will the damages be reduced by if there is contributory negligence? Good question. There is no clear answer to that. It really does depend on the facts of each case, although I've got a list of cases coming up when we get to contributory negligence, which gives you some idea of how much the damages will be reduced by. Okay, so a quick look at causation. So on the screen, we've got the two main issues with regard to causation. First of all, we should note, of course, that the burden of proof, hang on, why did it do that? I don't know. I thought it was supposed to be touch screen. Oh dear. Come back, mouse. Where are you? The burden of proof is on the plaintiff to prove causation on the balance of probabilities, okay? And causation is primarily a question of fact, but legal principles apply. Why do we say a question of fact? Well, first of all, the incident must pass the but-for test. And if there's only one possible cause, then that's the effective cause. I don't like using the expression causation on the facts or causation on the law. I think it's much easier and simpler to simply say, if there's only one possible cause, that's it. That's the effective cause. But your course manual does use those expressions, causation on the facts and causation in the law. If there's only one particular cause, then that's it, full stop. If you like, causation on the facts is the same as causation in law. But if there's more than one possible cause, then the courts will have to come up with the effective cause. And so that's what your course manual says, causation in law. And how do you know? Well, the court will apply the principle of novus actus interveniens. They will say if the second cause was reasonably foreseeable, then the first cause remains the effective cause. But if the second cause was not reasonably foreseeable, then the second cause becomes the effective cause. Okay. And with regard to the so-called but-for test, the leading case will be Barnett. Remember, the question is one of physical cause and effect. And in Barnett, the patient would have died anyway. He had that's a good word. He had drunk some tea with arsenic in it, and he would have died anyway. But Barnett's a useful case to go through because remember the elements of negligence. A duty of care, was that owed by the doctor? Yes, it was. Was there a breach of the duty of care in Barnett? Yes, there was, because the doctor acted too slowly and didn't come up to the standard required. But was there causation? The court said no, causation was not proved in Barnett, because even if the doctor had acted quickly, he couldn't have saved him. The patient would have died anyway. Okay. By the way, on page 59 of your course manual, there's a Hong Kong case, similar. Well, not similar, but a similar decision there. In Cheng and Secretary of Justice, it was a question of the plaintiff was unable to prove causation in that case. So it's the opposite result of Barnett. But in Barnett, the but-for test was applied. The plaintiff was able to prove that, and so they were able to claim, sorry, wasn't able to prove causation, therefore failed in their negligence action. So in both Cheng Loon Yin and Barnett, the plaintiff failed to prove causation, therefore they failed in their negligence action. Because remember the elements of negligence, there must be a duty of care owed by the defendant to the plaintiff. There must be then breach causing damage. And in Barnett and also Cheng Loon Yin and the Secretary of Justice, the plaintiff was unable to prove causation. Okay, so that's the first element, and then the second element is that even if the but-for test is satisfied, there may be another possible cause. Okay, and so the courts are going to have to come up with the so-called effective cause. This is what your course manual describes as causation in the law. Okay, and normally it's a matter of common sense, but if there is more than one possible cause, the court has to decide the effective cause, and they will look to see whether there has been a novus actus interveniens. What is novus actus interveniens? What does it mean? It says a new act intervenes and breaks the chain of causation. Well, how do you know whether there is a novus actus interveniens? Well, the court will apply the reasonable foreseeability test. And if the second cause was reasonably foreseeable, then the first cause will remain the effective cause. If not, then the second cause breaks the chain of causation, and it's the second cause which becomes the effective cause. So that's novus actus interveniens. So it does depend on the degree of foreseeability of the event, and I suppose also in how it actually occurs. Again, it's up to the court really on the facts of each case. You can't really lay down any general principle here. All these cases do depend on the facts that arise in that particular instance. Okay. Oh, there you go. I got a Kung Yi Fat Choi in Chinese. Thank you very much. There you are. I presume that's Kung Yi Fat Choi from Chan Pak. Sorry, I can't remember. Okay, good. The chat box is open, so if you've got any comments or indeed complaints, let me know. Okay, so I'm still letting people in. Okay. Let's not worry too much about natural events, because natural events, normally the chain's not broken because the event would be reasonably foreseeable, okay, such as, you know, we haven't had, the weather's been really good lately, we haven't had a typhoon or anything lately, but if there's an extraordinary rain or an incredibly strong typhoon, in other words, a very extreme weather event, that could possibly break the chain of causation if it is not reasonably foreseeable. Okay, so the leading case on novus actus interveniens, everybody, the must-know case, I would say, is on the screen, Natalie and Jones. And the facts of Natalie and Jones, remember, the defendant's negligence caused an accident at the tunnel exit. His car broke down, so that blocked traffic. So the police arrived to investigate and to unblock the traffic, manage the traffic flow. It was a one-way tunnel, so that's worth noting. And the plaintiff, the police officer on his motorcycle, took instructions from the superior officer, and he rode his bike against the flow of traffic and was injured. So it was the police constable who was suing here, and The question was, who do you sue? Because what was the effective cause of the police constable's injuries? Well, certainly the defendant's negligence caused the accident, so that satisfied the but-for test. But the second possible cause were the actions of the superior officer. Well, it's certainly reasonably foreseeable that the police would turn up to manage a traffic accident, but what was not reasonably foreseeable were the fact that the superior officer made lots of little errors which contravened the standing instructions for such an event. In particular, he did not close the tunnel to traffic, and he sent the police constable on his motorbike against the traffic flow. He could have used a telephone or radio to stop the traffic anyway. That was Natalie and Jones. So the actions of the superior police officer were not reasonably foreseeable. The fact that he had made so many mistakes, okay? So that's Natalie and Jones. Also, Wright and Lodge is a good case. You remember here, Natalie and Jones, page 65, Wright and Lodge on 66. Similar sort of situation in which the second cause was not reasonably foreseeable. You have, again, a car breaking down on an unlit highway. The driver was negligent when she tried to restart the car without first removing the car from the roadway. So then a lorry collided with the stalled car, and then several other vehicles collided with the lorry, resulting in injury and death. So you've got a chain reaction here. It was found by the court that the driver of the lorry drove the vehicle recklessly, and the actions of the lorry driver were not reasonably foreseeable. The actions and negligence of the lorry driver constituted an intervening act so that the driver of the stalled car was not liable for the losses and damages to the subsequent drivers. It was the lorry driver who was so liable. It was not reasonably foreseeable that the lorry driver would drive so recklessly. Okay, so there you are, Natalie and Jones, or Wright and Lodge. Fairly similar facts, vehicles breaking down on a highway or in a tunnel. And the court found in both cases that there was a novus actus interveniens. In Natalie and Jones, it was not reasonably foreseeable that the police officer, the superior police officer, would have made such a series of mistakes which went against the standing orders for police in such a situation. And in Wright and Lodge, it was not reasonably foreseeable that the lorry driver would drive so recklessly. So there was a novus actus interveniens in both Natalie and Jones and Wright and Lodge. Okay, the other cases on novus actus interveniens, everybody should know, not must know. I think that's really all we need to talk about with regard to novus actus interveniens. Again, the must know case, Natalie and Jones, and perhaps also Wright and Lodge. Okay, so just a quick review of novus actus interveniens. It is a question of reasonable foreseeability of the second event, but it really depends on the facts of each case. And of course, what do you mean by reasonably foreseeable? It's a very open-ended expression, open to interpretation. So we do have some case law, such as Natalie and Jones and Wright and Lodge does provide some general guidance, but as I say, it really does depend on the facts of each case. Also, there are some, this is should know, sort of academic argument, policy considerations are at play. Okay. Also, the court perhaps also will look at the situation with regard to compensation. Will the plaintiff get proper compensation? Okay. All right, so that's novus actus interveniens, and that is causation. So going right back to the top again with regard to causation and wrapping it up. Remember, it's two aspects, the but-for test. Does the incident satisfy the but-for test? And the leading case will be Barnett on the but-for test. Remember, the person who drank the tea laced with arsenic would have died anyway. So there was no causation. There was no cause and effect. And if there's only one possible cause, then that's it. That is the effective cause. If there's more than one cause, then the courts will look to see whether the second cause is a novus actus interveniens, which breaks the chain of causation. And the test will be, is that second event reasonably foreseeable? And because of reasonably foreseeable is a very vague expression, open to interpretation, it really does depend on the facts of each case. But as I say, the leading cases on novus actus interveniens, I would say Natalie and Jones, stroke Wright and Lodge. So this topic of novus actus interveniens and also causation in general, probably if you get a question in the exam, will be in part A of the exam. It could be half a question in part A of the exam, which would be 10 marks. So if you get it, it should not be a difficult question. It could be in past exam papers simply ask, explain what is meant by novus actus interveniens. Well, thank you very much. Okay, that would not be a difficult question. Your must-know cases, Barnett, on the but-for test, and then Natalie and Jones, stroke Wright and Lodge. And of course, it's always good to throw in a Hong Kong case. So perhaps, I'm trying to find the page reference again, perhaps Cheng Union on page 59 in the Secretary of Justice. That could be a good case to throw in as well, because it's good to have a Hong Kong case as well as an English case when it comes to these issues. Okay, everybody, so that's a quick review of causation. Now let me get on to causation number 2. Where is it? I'm trying to find it here. Yeah, okay. The other part that we need to review, everybody, is under the heading remoteness of damage. I want to just emphasize again the thin skull rule. Where is it? There it is. The thin skull rule is must know. And so we need to have a quick look at this again, because this can come up in the exam question. Again, probably part A of the exam and probably half a question. So the thin skull rule is covered on page 69 of your course manual. And the must know case is Smith and Leach Brain. Smith and Leach Brain, what an awful case name, which is good because that can help you remember the case. All right, if you case names with rather odd names are the ones that are easier to remember. I've got Smith, of course, is a very common English name. Leach Brain sounds like a horror movie, you know, leeches eating your brain. Oh my goodness. Okay, so the facts of Smith and Leach Brain on page 69. An employee received a burn on his lip when he splashed by molten metal. Ouch. Okay, now, of course, the skin on your lips is very thin, but again, this particular, so you think you might get some sort of injury, yes. But in this particular case, the plaintiff contracted cancer from the burn and died. Well, most people wouldn't get cancer from being burnt by molten metal. Okay, you get some sort of injury, but you wouldn't think you'd die from cancer. But he did, and so there was a negligence action started, and the court found that apply the principle, you take your victim as you find him, and the fact that the employee contracted cancer from the burn and therefore died, you take your victim as you find him. It's bad luck if you injure somebody who is very sensitive, so to speak, because the main function of tort law, everybody, is compensation. And so the court applied the thin skull rule in Smith and Leach Brain, so the defendant was liable. Also interesting to note, it was an employment contract, so without sounding a bit cynical, the courts usually are on the side of an employee when they are suing an employer, because the employer is under quite a heavy duty of care with regard to safety of employees. Okay, so applying the thin skull rule to other situations, if you're in a traffic accident and you collide with another car and you're at fault, make sure you hit a car a little bit like my old little car which I haven't got, which wasn't very valuable. Don't hit a Rolls Royce or a very expensive car, because you would have to take your victim as you find it. Actually, I nearly ran into somebody's Ferrari the other day, not in my car, sort of almost tripped on it. Well, there you are. Some people do have a lot of money to buy these cars. Okay, Simmons and British Steel is also a useful case to cite in this situation, in which the plaintiff warned his employer that his working conditions were dangerous. The employer failed to take remedial action, and then the plaintiff was injured in a fall while working. And during his hospitalization, the plaintiff became overwhelmed with anger. He said, I warned him so many times that he didn't do anything. And he got so angry that he suffered from a psychiatric injury. Okay, well, again, bad luck. Okay, so you take your victim as you find him, and the House of Lords found that the thin skull rule applied. The duty of care which the defendants owed to the plaintiff extended to the psychiatric symptoms as well as to the physical consequences. Okay, you must take your victim as you find him. So the aggravation of the psoriasis, which is the skin disease, and the anger which led to his depressive mental illness can both be assumed to fall within the scope of their liability, as long as there was a causal connection between these symptoms and the accident. Okay, so thin skull rule, everybody must know. It does sort of come under the heading, the general heading of remoteness of damage, but the courts are saying that the thin skull rule survives the remoteness rules laid down in the wagon mound case. Okay, so remember, what type of damages will a defendant be liable for? Well, only those which are sort of reasonably foreseeable, and you will be reasonably foreseeable for the types of damage which the plaintiff might suffer. And so you might say, hang on, does this clash with the thin skull rule? Well, the courts are saying no, the thin skull rule does survive the wagon mound remoteness rules. Okay, so what's on the screen, everybody? Must know, must know. Smith and Leach Brain is your leading case, but it's good to, I think, also cite Simmons, because Simmons is a much more recent House of Lords decision. So there you are. Okay, so that's a review then of causation and also the thin skull rule. Okay, now we'll get on to defences, if I can find them. Where are you? There you are. Okay, so we'll be spending most of the rest of this evening now on defences to negligence, which are also defences to occupier's liability. Now, of course, occupier's liability is not really part of our syllabus, but it's worth mentioning, it should know, in that occupier's liability is similar, very similar to negligence, and I will be taking you through the material on occupier's liability later, not today, probably in the last lecture, because there is legislation on occupier's liability, and even though it's not must know for our course, I think it certainly should know, and it's also, by looking at occupier's liability, we will also be indirectly revising the work on negligence, because occupier's liability is very similar to negligence. The only difference is that with occupier's liability, the defendant is always somebody who controls premises, is an occupier, and the duty owed by an occupier is to visitors on the premises. And the duty that is owed by an occupier is very similar to the duty of care. In fact, there is a special name for it. It's called the common duty of care. So there are very similar elements with occupier's liability to negligence. Okay, so we're looking at defences now, and remember defences are relied on by the defendant. So let's go through everybody. First of all, by way of review, the elements of negligence. You know them, don't you? There must be a duty of care owed by the defendant to the plaintiff. Then there must be breach of duty, and of course that depends on the standard of care. And remember, the standard of care will be that of the reasonable defendant in the circumstances. So the standard of care does vary, except for car drivers. Don't forget that when it comes to breach of duty of care. For car drivers, there's only one standard of care, that of the reasonable competent driver. Nettleship and Weston, very important case on the standard of care for car drivers. There's only one standard for car drivers. But apart from that, the standard of care does vary depending on who the defendant is. Okay, so remember we looked at those cases involving children. Obviously that's an ordinary child of that age, that would be the standard, etc. And we looked also at professional people. All right. And also the court will look at various factors in deciding whether there is breach of the duty, such as how often does this event occur, the seriousness of the potential injury to the plaintiff, okay, and all the circumstances. What would a reasonable plaintiff do in those circumstances? Remember Wishing Long Hong? Remember the employer was held to be in breach of duty because a reasonable employer would have provided sufficient lighting to employees. Okay, we're going to visit Wishing Long Hong again when it comes to contributory negligence. So watch out for Nettleship and Weston and Wishing Long Hong and Wong Kit Chung. Those two cases are good must-know cases because they are relevant to two separate issues. Nettleship and Weston deals with breach of the duty of care by a car driver and also the defence of contributory negligence. Wishing Long Hong also is a case on breach of duty in which the court found that a reasonable employer would have provided more tortures. In Wishing Long Hong, remember there were 6 employees walking in the early morning. Yeah, they were up there to watch the sun get up. 6 employees, only 3 torches, and one of the employees who did not have a torch fell down and got killed. Okay, so there was breach of the duty of care in Wishing Long Hong. But also in Wishing Long Hong, as we'll see, the defence of contributory negligence is relevant. Okay, so I mentioned those 2 cases now. Nettleship and Weston and Wishing Long Hong are 2 cases, and they are both relevant to 2 separate issues. Well, they're both relevant to breach of duty and both relevant to the defence of contributory negligence. So good value cases, if you like. And then, of course, causation we've just looked at. Remember, causation, the plaintiff has to make sure the but-for test is satisfied. Okay. And then remember, possibly there could be a novus actus interveniens. Also, the damage must not be too remote. Of course, there must be damage. And remember, with regard to damage, everybody, what type of damage has been suffered by the plaintiff? And remember when we did the work on duty of care, if the damage suffered by the plaintiff is directly caused personal injury or property damage, then it's Donoghue and Stevenson. All you need to show is reasonable foreseeability for a duty of care to be owed. So the type of damage suffered by the plaintiff is relevant to the issue of duty of care. And remember, if the damage is nervous shock or pure economic loss, then the plaintiff will have to prove that extra element of proximity. Okay, all right. And then, of course, that brings us on to what we're about to look at now, defences. Okay, so who has the burden of proof? Who has the burden of proving duty? Plaintiff. Who has the burden of proving breach? Plaintiff. Who has the burden of proving causation? Plaintiff. Who has the proof of proving damage? Plaintiff. Who has the burden of proving any of the defences? Defendant. So watch out for that. A lot of students forget defences when it comes to questions in the exam on negligence. So don't you be one of them. Okay, so what are the defences? Well, there are three of them. The first two are total defences. Valentine non-fit inuria is also known as consent. Okay, so it's, I forget the exact Latin expression. Maybe it's in the notes, I'm not sure. But you know who a volunteer is, right? Somebody who consents to doing something. I volunteer my work. So there must be consent to the risk. Valentine non-fit injuria, voluntary assumption of risk. That's what it is. The other defence, then we did have a close look at Valentine last time, but we'll review that again tonight. And then exterpy causa, non-fit, non-orata actio, normally shortened to just exterpy causa, meaning illegality. And if there is illegality, then that is a total defence. And then we get on to the most important defence, contributory negligence. Contributory negligence, everybody, used to be, I emphasise used to be, at common law, and I emphasise again, at common law, a total defence. But it is now only a partial defence because there is now legislation, and it's must-know legislation, and we will be looking closely at the wording of Section 21 of LACO later on tonight. So Section 21 of LACO, everybody, is must-know, must-know. Don't you forget Section 21 of LACO in the exam. And what some students do, and I always tear my hair out. Oh no, don't you miss Section 21 of LACO. There is not much must-know legislation on tort law. Okay, I've given you some. Remember Section 62 of the Evidence Ordinance, I suggest is must-know. Okay, remember Section 62 of the Evidence Ordinance is an aid in helping the plaintiff prove breach of the duty of care, because if the defendant has been convicted of a relevant criminal offence arising from that particular accident, then evidence of such conviction can be used in this civil action. And it's very strong evidence, and not only that, the burden of proof is reversed and put on the defendant. Okay, so that's Section 62 evidence order, and of course Section 21 of LACO, which we're going to go through tonight, is also must know. There is one other further piece of legislation which is not in your course manual, and I did mention it briefly last time, and I'll mention it again tonight, and that's going to be Section 12 of the Motor Vehicle Insurers Third Party Risk Ordinance. Okay, long title, and it's not in your course manual, but I think you'll agree, and we did cover it last time, it is very, very important. I don't know why it's not in your course manual. Anyway, so exterpy causa, though, is a total defence, contributory negligence, partial defence. Which one does the court favour? Well, no prizes for guessing. It's contributory negligence, because it fits in with the main function of tort law, which is compensation to the victim. Okay, and if Valentine or exterpy causa succeed as defences, then the plaintiff will get no compensation. With contributory negligence, even if the defendant is able to prove contributory negligence, the plaintiff will get some compensation. Okay. So let's get on to Valentine by way of revision, because we did get this far last time. Remember, in English, it means voluntary assumption of risk, and indeed, it is a complete defence. Okay, something fell down. Just a minute. Oh, yes. Sorry. Oh, that's a clip. I don't know where that comes from. All right, okay. So what must the defendant prove in order to succeed in proving Valentine? He must prove that the plaintiff had knowledge of the risk, and two aspects to that. knowledge of the nature of the risk and the extent of the risk, and then had agreed to accept the risk. That is, waive his rights. Waive means to give up or forfeit your rights, and indeed had acted voluntarily. Okay, so there's a good quote, by the way, which is relevant to this on page 125 in Haynes and Harwood. Okay. Well, actually dealing with rescues. I'll get to that a bit later. I can forget about it. All right, so let's have a look at cases on Valentine. And in Shotwell, Morrison Murray, Titchener and Geary, the defence of Valentine all succeeded, but the defence did not succeed in IP and film power. So I would say the must-know cases here are Shotwell and IP and film power, because you've got two cases with contrasting results. Always good to learn cases which have contrasting results. I won't say on similar facts, but they are contrasting results. So let's have a look first of all, by way of revision, at ICI and Shotwell on page 121 of the course manual. And remember, it was the hungry explosives worker. Okay, so the plaintiff and his brother were employed by the defendant to work in the defendant's quarry. The brothers were instructed to carry out explosive work, but they were hungry, and in order to save time, they did not follow the safety instructions given by the defendant to test detonators under a proper shelter. They did it in the open air, the open space. So the plaintiff was seriously injured in an explosion during the test. And then he sued his brother for negligence and the defendant as employer based on vicarious liability. Not very nice to sue your brother, but anyway. Well, there you are. But just remind us, everybody, what vicarious liability is. You know what vicarious liability is in the employer-employee relationship. The employer is liable for damage caused by the torts of his employees acting in the course of employment. So vicarious liability was relevant in the Shotwell case, and the House of Lords, though, refused to accept the defence of, refused to grant the plaintiff's claim because the defence of Valentine succeeded. The court held that the plaintiff had acted voluntarily, had voluntarily assumed the risk. He had knowledge of the risk because, you know, he was in that field. He was an expert in that field. He knew the nature and extent of the risk. He had agreed to it and had acted voluntarily. He nevertheless elected to go ahead with the test in an open space. Okay, I mean, you don't have to sit down and put pen to paper and come up with an agreement, but I mean, on the facts, obviously agreed to it. But you know, this idea of an agreement, okay, wasn't really seriously considered by the court here. But the elements were established. Voluntary assumption of risk. In Shotwell, the plaintiff had knowledge of the risk. He agreed to accept the risk and had acted voluntarily. So the defence of Valentine succeeded in Shotwell. By contrast, in IP and film power, on page 123, plaintiff who was a part-time stuntman engaged to perform a stunt for a film. He was supposed to drive the minibus and forced the minibus to drive into the sea as if it had lost control of it. Well, it did plunge into the sea. In fact, went right to the bottom of the sea. Plaintiff was unable to swim to the surface as was planned, nearly drowned because of insufficient safety precautions taken by the filmmaker. And of course, there was sued him for negligence, and the court, the defendant pleaded Valentine, but the court disagreed. They said that there was not voluntary assumption of the risks. The plaintiff did not really consent to the risk because he would assume that all the necessary safety procedures had been put in place, but they were not put in place. Okay. the defendant had failed to provide adequate safety measures. Okay, so the defence of Valentine did not succeed in IP and film power. Didn't actually say what his injuries were, but he nearly drowned. Presumably he had some sort of physical injury as a result of that. Who knows? Perhaps even psychiatric injury. I don't know. But presuming, I'm not sure what the damage was in IP and film power. But the important point from our point of view is that the defence of Valentine did not succeed in IP and film power. So see a contrast. Okay. Morrison Murray, interesting case. The point about Morrison Murray, obviously Valentine was established. There was a voluntary assumption of the risk because the passenger on the plane knew that the pilot was drunk. He had knowledge of the risk. And of course, you're in a plane, obviously there's a big danger there. He had agreed to accept the risk because he's the one who climbed on board the plane. He had acted voluntarily, and so the defence of Valentine succeeded in Morris and Murray. But I put a note on the screen here. In Morrison Murray, it was a aeroplane, not a vehicle on the road. Okay, and we look at the next PowerPoint, I think it's the next one, in which if you're in a vehicle on the road, Valentine does not work because of Section 12 of the Motor Vehicles Insurers Third-Party Risk Ordinance. Passenger agreements shall be of no effect. Okay, but Morrison Murray was not a vehicle on the road, therefore the defence of Valentine did succeed. Also, in other cases, which are in your course manual, Titchener, where's Titchener? On page 121, Titchener and the British Railways Board, the court found that there was Valentine. There wasn't actually an agreement as such. Okay, you need not have an agreement as such, but there certainly was a voluntary assumption of risk in the Titchener case. All right, the plaintiff was trespassing on railway premises. After slipping through a fence, she went across the railway line and was hit by an oncoming train. House of Lords says she clearly knew the risk of being hit by a train when crossing the line, yet she decided to take the risk. So even if the driver of the train was negligent, and defence of voluntary assumption of risk by the plaintiff was available to the driver, okay, but on the facts, the court found that there was no negligence because there was the total defence of Valentine. Okay, the plaintiff had voluntarily accepted the risk. That's the Titchener case. And in Geary, on page 121 as well, this is the case about people sliding down the banister stair in a late 19th century gentleman's club. By the way, it's good to see that the restaurants and bars in Hong Kong are now open again, at least till 10 p.m. I mean, I was starting to get a bit fed up with the fact that everything in Hong Kong was closing at 6 p.m. I mean, did the virus sort of go to sleep after 6? I don't know. Anyway, here we are. And so in this case, the premises contained a large open staircase with banisters on each side, and from time to time customers had been tempted to slide down the banisters. Obviously this is risky, particularly if you're half drunk. Some had injured themselves as a result, and in this case Gary visited the pub with some work friends, and on leaving the pub she attempted to slide down the banisters. Obviously got injured because she fell off, had a spinal fracture resulting in, oh my goodness, she tetraplegia. Tetraplegia means lost the use of legs and arms. She admitted she had appreciated there was an obvious risk of falling attached to the action, so there's a voluntary assumption of risk. Okay, she did though try to argue contributory negligence, but the court disagreed. Okay. The claimant was the author of her own misfortune. As such, the defendant owed no duty to protect her from an obvious and inherent risk. You invite a person into your house to use the staircase as a staircase. You don't invite them to slide down the banisters. Okay, so in all the cases on the screen, the defence of Valentine succeeded, total defence, except IP and film power. Okay, so was there a voluntary assumption of risk? Okay. Okay, good. Somebody's having hot pot. Well, aren't you lucky? Okay. Suicide cases. Is Valentine relevant to suicide? The answer now is normally not, even where the victim is of sound mind. The law used to distinguish between suicide victims who were of a sound mind and those who were not of a sound mind, but that distinction is now gone after the Kirkham case, and so there's no distinction between a victim who is of sound mind and one that is not of unsound mind. But Valentine, the courts have decided, is not the suitable defence in suicide cases. The appropriate defence in suicide cases will be contributory negligence. But of course, how much will the damages be reduced? Well, you'll see that in the Reeves case, it was a 50% contributory negligence. So that's quite a big reduction, but of course there's a lot of fault in it. It's even if you don't know what you're doing, even if you knew what you're doing, it's still, you knew what you were doing, so you should have some big reduction in your quantum of damages. Okay, of course, the suicide succeeded, so it wasn't the victim who can claim damages, it would be their personal representatives. Okay, so that's so what's on the screen, everybody more should know than must know, except to emphasise the fact the courts prefer partial defence of contributory negligence to the total defence of Valentine in this case. What about rescuers? And this is on page 125. So what happens if you're a rescuer acting to save another? Does the defence of Valentine fit in? Well, you would think no, because this is a spur of the moment type of thing, right? And Haynes and I'm not sure whether you got this PowerPoint, by the way, everybody, so you might want to check and add this in, because it's on page, what page is it? It's page 125 of the course manual. Again, should know, not really must know cases, but it's interesting. What about rescuers? If you go and rescue somebody and you get hurt, can they raise the defence of Valentine? Well, no, because if you're acting to save another's life, okay, well, you shouldn't be barred from claiming damages because of the defence of Valentine. Okay, the court in Haynes and Harwood refused to allow the defence of Valentine where a policeman was injured trying to stop horses from running into a crowd of people on a street. I suppose you could apply that in the modern day situation to a car trying to run down people. Okay. Runaway horses, there you are, Haynes and Harwood. And it's a case from 1935. Okay. Also, another case on page 125, Hong Kong case, Tam Xiao Fong. Plaintiff was a home care worker assigned by her employer, the defendant, to take care of an elderly man, but then there was some sort of fight while she was working at his home. No, argued, and there was physically attacked the neighbour, but then the plaintiff attempted to restrict. So somebody's coming in trying to break up a fight. Well, always a bit dangerous. Are you is this Valentine? And the court said no. If you're acting to save somebody, even if it's an attempt to save them from themselves, then the defence of Valentine will not apply. Okay, so there you are. This, of course, you could argue is a situation of you're encouraging people to rescue people who are outstretched. Okay, so the quote in Haynes and Harwood is the one on page 25 I was referring to before, where a plaintiff acts to save another from injury. He's not deemed to assume the risk of the consequences, even if he acts voluntarily and with full knowledge of the danger. Okay, because this type of a reflex action, practically a reflex action. You see somebody in trouble, of course you want to go and help them. Oh my goodness, that does remind me when I was at the airport once, and I just finished a walk along the airport trail. I was on my way back to Tung Chung, and a man was rushing to catch a plane. He ducked under a staircase and banged his head. Blood everywhere, all over the ground. He had a handkerchief which was red from blood, and he was obviously stunned. So I stopped and helped him across the road, and I managed to get him medical assistance. Now, if I had been sort of injured somehow or other in helping him, well, the defence of Valentine wouldn't apply. It was a reflex action. I mean, I thought this guy needs help, so I helped him across the road. By the way, when you go to the airport next time, when that will be, you might notice there is, under that staircase near one of the lifts, there is a sign which says in big letters, yellow and black, "Mind your head." Mind your head, because that particular gentleman did not mind his head. He was in a hurry, banged his head against a steel bar, okay, and the airport authority took action after that. And if you have a look at that staircase now, they've got the sign "Mind your head." That was put there after this accident, and they've also moved in these very heavy flower pots to stop people running under that iron staircase. All right, so there you are. I guess I was sort of a rescuer. Okay, poor guy, he was absolutely stunned, and he didn't say one word to me, but I presume he's okay. All right, there you are. So if you were in a situation to rescue somebody, don't worry, Valentine will not apply. Okay, good. So moving on to the legislation we looked at before, statutory restrictions on Valentine. Your course manual does mention Section 1 of the Control of Exemption Clauses Ordinance. But, and remember, you know from our contract law studies, okay, that under the CECO, what is an exemption clause, by the way, and it's a clause in a contract which seeks to exclude or restrict liability for either negligence, breach of contract, or misrepresentation. Well, obviously here we're talking about negligence. So will an exemption clause be effective as a defence against negligence? Okay, and the courts are saying, hang on, you cannot exempt liability for negligence causing death or personal injury. That's section 7.1 of the CECO. You can exempt liability against other types of loss, but only if it is reasonable. Okay, so you could argue that if there's some form of notice warning people, you know, be careful, you know, if you enter this building, you do so at your own risk. Will that be an effective defence? Will that be an exemption clause? Well, it will not work if you're trying to exempt liability for negligence causing death or personal injury. Okay, so exemption clauses is an area of contract law which overlaps with tort law, because an exemption clause is trying to be raised as a defence to a claim for negligence, as well as the others, misrepresentation and breach of contract. Okay, the other and very important piece of legislation, Section 12 of the Motor Vehicles Insurers Third-Party Risks Ordinance, should be in your course manual. I think you all agree with me, it's very important. And I've extracted the important words from Section 12, which says that passenger agreements shall be of no effect. So if you're a car driver and you're driving along and you want to give somebody a lift, and you say to them, I'll give you a lift providing you agree not to sue me if there's any sort of accident, well, such an agreement shall be of no effect. Valentine will not work as a defence involving a vehicle on the road. It has to be a vehicle on the road. This is why it did not work in Morrison Murray, because in Morrison Murray it was an aeroplane, which is not a vehicle on the road. The leading case you could cite, though, with regard to vehicles on the road is Pitts and Hunt. And Pitts and Hunt's a good case because it's relevant not just to Valentine, it's also relevant to exterpy causa or illegality. Okay, so I'm looking to find out where Pitts and Hunt is. because Pitts and Hunt is a case on both Valentine and illegality. Okay. Pitts and Hunt, by the way, is on page 127. It's actually under the heading Exterpy Causa. Pitts and Hunt was also a case on Valentine, because when you look at the facts of Pitts and Hunt, you'll see it looks like the plaintiff had agreed, had voluntarily assumed the risk, because Pitts and Hunt had been drinking together before Pitts rode on the back of a motorbike. So the motorbike was a vehicle on the road, and it was being driven by Hunt. Pitt knew that Hunt was drunk, that Hunt did not possess a driving license, also is under the legal age for driving, and also is uninsured. They are all criminal offences. It also encouraged Hunt to drive recklessly with the intention of deliberately frightening other road users. Well, that's what grounded a claim in Exterpy Causa. But Hunt was killed in an accident. Pitts was seriously injured. Pitt's claim against Hunt's personal representative failed not because of Valentine, it failed because of Exterpy Causa. So Valentine was pleaded in Pitts and Hunt, but the English legislation, very similar to Hong Kong, says that passenger agreements concerning vehicles on the road shall be of no effect. So in Pitts and Hunt, the defence of Valentine did not succeed. What did succeed was the defence of Exterpy Causa. So watch out for that, okay? And in Pitts and Hunt, no Valentine, even though the plaintiff actively encouraged the reckless riding. There was a voluntary assumption of the risk in Pitts and Hunt, yes, but the court said such agreements shall be of no effect. So the effective defence in Pitts and Hunt will be Exterpy Causa or illegality, not Valentine. So be clear on that. And of course, the facts of Pitts and Hunt are quite graphic, so it's sort of easy case to remember. All right, so that finishes our work on Valentine, which is good timing, because that then brings us on to the next important defence to negligence, which is Exterpy Causa or illegality. Okay, and you'll notice that here we also mention Pitts and Hunt. Okay, so I think though it's probably a good time, everybody, to have our first break. So after the break, we'll come back, have a look again at Pitts and Hunt, and you'll see that in Pitts and Hunt, the defence of Exterpy Causa did succeed. All right, the defence of Valentine, though, remember, did not succeed. So let's have our first break. After that, we'll carry on with the defence of Exterpy Causa. Okay, welcome back everybody. Ready to go again, as I've mentioned in the chat box. So the chat box remains open, so if you have any comments or questions, just drop me a line. Okay, so we carry on now with our defences to negligence. We've already covered Valentine. Remember, Valentine is a total defence, so that if the defendant succeeds in proving Valentine, the plaintiff gets no damages. Similarly with Exterpy causa or illegality, this is a complete or total defence. And again, if it succeeds, if the defendant successfully pleads exterpy causa, the plaintiff will end up with no damages again. So that does not fit in with the main function of tort law, which is compensation to the victim of the tort. But exterpy causa is a complete defence because it's based on the public policy that the law will not support crime. Okay. But what must the defendant prove in order to establish the defence of illegality or exterpy causa? And remember, the defendant has the burden of proving any defence. He who asserts must prove. That's the general principle. So if you are relying on a defence, you've got to prove the elements of the defence. So what are the elements of the defence of exterpy causa? Well, they're on the screen. Number one, that the plaintiff was acting illegally when injured. So that's a question of fact. That the injury was closely connected to the illegality. And this slightly controversial point, illegality must be sufficiently serious to defeat the plaintiff's claim. That is, the public conscience would be offended if the plaintiff's claim succeeds. This case of Saunders and Edwards, though, which is not in your course manual, but I like Saunders and Edwards because it has very good imagery. Remember, Madam Justice, with the picture of Madam Justice, she is blindfolded, she's wearing a long dress, and she's holding the scales, balancing the scales, one on each arm, all right? So remember that imagery. And in Saunders and Edwards, the court said the court should not, at the first hint of illegality, draw up its skirts and refuse all assistance. So Madam Justice will not draw up her skirts and run away just because there's a little bit of illegality. So it does sort of raise issues here. What is illegality? How do you measure illegality for sufficient seriousness? Well, I'll tell you now, everybody, not wearing a seatbelt would not be sufficient to ground a claim for illegality. But it is a crime, okay? All right, we have a student. I think I've let everybody in, so everybody should be there. Okay, all right. Okay. So there you are, Saunders and Edwards. So the court should not, at first hint of illegality, draw up its skirts and refuse all assistance. Okay. Now let's pose some scenarios here. For example, if you decide to rob a bank, which you shouldn't do, of course, and you and a friend are on your way down to the Hang Seng Bank because you want to rob it, and you'll be wearing your masks anyway. Okay, that's always my joke. Well, if you're in an accident on the way to the scene of the crime, well, Valentine would not apply, exterpy causa would not be relevant there because it would not be sufficiently connected with, there wouldn't be sufficiently close connection to the illegality. The illegality will be robbing the bank, okay? However, if you're actually in the process of robbing the bank and you slip on a wet floor of the bank and you injure yourself and you sue the bank for negligence, well, bad luck, the defence of exterpy causa would succeed there because there would be the close connection with the illegality, okay? And of course, it would be sufficiently serious if you're robbing a bank, certainly. So pretty well all crimes are sufficiently serious to ground a claim in exterpy causa, but I'm telling you now, everybody, not wearing a seatbelt is illegal but that would not be sufficiently serious to ground a claim for illegality. Okay, Madam Justice would not draw up her skirts and refuse all assistance if it's just not wearing a seatbelt. Can't think of any other crime that wouldn't, wouldn't be serious. And that's the question that's posed on the screen. How do you measure illegality for sufficient seriousness? Also, again, this is more academic argument. Does not the classifying of illegality by the court according to degree send the wrong message to the public? That is, some crimes are not so bad. Well, I mean, not wearing a seatbelt, that's fine, okay. I mean, also, you could argue, doesn't contributory negligence provide an adequate solution? Yes, you could argue that as well. The courts are more willing to provide, suicide used to be a crime. That's what this is getting about. Suicide used to be a crime, it's no longer a crime, and this is what these cases are all about. So in the Reeves case and also Kirkham, the court found that the appropriate defence would be contributory negligence now, not illegality. All right. But again, suicide used to be a crime, it is no longer a crime. Okay, but I would say the must-know case on illegality, everybody, is probably Pitts and Hunt again. Pitts and Hunt is the motorcycle driver, okay? And remember, Pitts and Hunt, Valentine did not succeed in Pitts and Hunt, but it did succeed. Exterpy causa, did succeed in Pitts and Hunt. Why? Because in Pitts and Hunt, the Pitts encourage Hunt to drive recklessly, and that is a crime, okay, with the intent of deliberately frightening other road users. It was almost as if Pitt was much more culpable than Hunt. Okay, I mean, Hunt was culpable because he was drunk, he didn't have a driving license, he was underage and uninsured. Okay, so there you are. Sort of a lesson here, everybody. Alcohol and vehicles do not go together. Okay, all right. So there you are. Pitts and Hunt, good case. Remember, Pitts and Hunt, there was no Valentine. Why? Because there's this statutory bar on Valentine involving a vehicle on the road. But in Pitts and Hunt, the defence of illegality did succeed. Okay, and it was a complete defence, and based on the public policy that the law will not support a crime. Okay. So that's Exterpy. And remember, in Pitts and Hunt, the defence did succeed. The plaintiff was acting illegally because he was encouraging Hunt to break the law. So that's a crime in itself. His injury was indeed closely connected to the illegality because he was injured while being on the motorbike with Hunt. And certainly it was sufficiently serious because, I mean, this was not just not wearing a seatbelt, it was actively encouraging somebody to break the law, to drive recklessly with the intention of deliberately frightening other road users, okay? So that's a very serious offence, certainly sufficient to ground a claim for exterpy causa. But note at the bottom here, I've got seatbelts. Not wearing a seatbelt, everybody, would not be sufficient to ground a claim for exterpy causa. Not wearing a seatbelt, everybody, the relevant defence will be contributory negligence, okay? But, I mean, it's possibly worthwhile raising very briefly in an exam question, and quite often exam questions involving negligence. I'm talking about the 40-mark question in the exam, Part B, Section B. And quite often you're given a fact scenario involving a traffic accident and the plaintiff is not wearing a seatbelt. Well, you could argue possibly a defence there of illegality, but Saunders and Edwards say that would not be sufficiently serious to ground a claim for illegality. The relevant defence would be contributory negligence, which is what we're about to get onto now. Okay, so contributory negligence. is the most important defence to a claim for negligence? And your course manual's pretty good on contributory negligence, starting on page 130. So let's go through contributory negligence. What is it? It's the plaintiff's failure to take reasonable care for his own safety. He is at fault. So, and indeed, the defendant does have to prove that the plaintiff is at fault, okay? And that the plaintiff's negligence is either a cause of the accident or causes a worsening of his injuries, or indeed property damage, okay? And also, we should note that the defendant has to prove that the plaintiff's conduct falls below the standard expected of a plaintiff in those circumstances. Also, you have to also prove causation. You have to prove that the act was a cause of the accident, or at least cause a worsening of the damage. Okay. So it's sort of like negligence in reverse. It's the defendant proving the plaintiff was at fault, and so the defendant has to prove that the plaintiff, if you like, committed an act which caused the accident. So he's got to prove causation. Also, if you like, that the plaintiff dropped below the standard expected of a plaintiff in those circumstances. Now, there's a lot of case law on contributory negligence, because contributory negligence used to be a total defence. It replaces but now we have legislation. And as I mentioned before, must know section 21 of LACO, Law Amendment Reform Consolidation Ordinance. So we're on page 130. And we need to look closely at the wording of section 21, sub 1. Okay, and remember, contributory negligence now is not a total defence. It used to be a complete defence. Even if the plaintiff was only a little bit at fault, even 1% fault, then that could be around a claim for contributory negligence, but that no longer applies. Okay. So I've amended this PowerPoint slightly, everybody, so you might want to have a look at this. I've amended it as a result of a comment from a student before who was wondering about this fact. But remember, contributory negligence used to be a complete defence. Used to be, okay, even if the plaintiff was only a little bit at fault, okay. But now that is no longer the law. The common law has been replaced, and the contributory negligence is now only a partial defence. And so the principle of apportionment arises, and this comes from the wording of section 21 sub 1 on page 130. So highlight section 21 of LACO must know. And if you get any question in the exam dealing with contributory negligence and you don't mention section 21, I'll be very disappointed, and so will you, because you will miss out on a lot of marks. Okay, sorry, I've just had my sip of my hot coffee, keep me going. All right. So I'm reading the middle of page 130. It says, where any person suffers damage as the result partly of his own fault. Partly of his own fault. So the plaintiff has to be at fault partially. And partly of the fault of other person or persons, a claim in respect of that damage shall not be defeated by the reason of the fault of that person suffering the damage. In other words, you can still claim and get damages, but the damages recoverable in respect thereof shall be reduced. So highlight the word reduced. Big question then is, reduced by how much? Good question. Well, the wording doesn't help too much with regard to actual numbers, but it says, but the damages recoverable in respect thereof shall be reduced to such an extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. So the court has to make an assessment of how much the plaintiff in particular was at fault. Okay, all right, so there you are. That's section 21, sub 1. It's up to the court, but the defendant has to prove that the plaintiff is at least partially at fault. Okay, so that really depends, it's a bit about, what is the standard of a reasonable plaintiff in those circumstances? That's the way the courts approach it, and we'll look at that issue now. So let's have a look at the seatbelt cases. Okay, and must know Ho Wing Cheung on page 137. Ho Wing Cheung is the leading case in Hong Kong on contributory negligence where the plaintiff was not wearing a seatbelt. Okay, and interesting thing about this, first of all, you have to ask yourself, would a reasonable plaintiff wear a seatbelt? That is the issue with regard to the standard of care with the seatbelt cases. And the English courts in Freeman Butcher in 1976 said, yes, a reasonable person would wear a seatbelt. Okay. By the way, seatbelts haven't always been with us. They were only introduced in the 1970s. Okay, but now it's sort of every car is fitted with a seatbelt, even minibuses. Okay, so there was a bit of an argument here when seatbelts were introduced. Some people say, well, it's up to me, isn't it? If I don't want a seatbelt, well, I'll take the consequences. Okay, but no, the courts are saying, starting with Freeman Butcher in England, that a reasonable person would wear a seatbelt. And that's followed in the Hong Kong case of Ho Wing Cheung. And in Ho Wing Cheung says that a reasonable person, or use the word of Lord Denning in Freeman Butcher, a person of ordinary prudence in England would take the precaution of wearing a seatbelt where it was available. Okay, and Chief Justice Roberts held that the ruling was applicable to Hong Kong by virtue of the application of English law ordinance. So Hong Kong followed England, Ho Wing Cheung followed Freeman Butcher. A person of ordinary prudence in Hong Kong would take the precaution of wearing a seatbelt where it was available. So if you don't wear a seatbelt, then you are at fault. That's the point. But it does depend on the circumstances. So watch out for Chan Wing Kim. In Chan Wing Kim on page 137. Highlight Chan Wing Kim because the court found that the second plaintiff's failure to wear a seatbelt was not unreasonable in the circumstances. Why? Because she was 5 months pregnant. Therefore, she was not contributory negligent, because the court will look at all the circumstances of a case, and it was reasonable in the circumstances of Chan Wing Kim that the pregnant lady not wear a seatbelt. Okay, so what are the must-know cases here? Ho Wing Cheung says that a reasonable person in Hong Kong would wear a seatbelt. So if you're not wearing a seatbelt, you are below the standard of care that the plaintiff would be expected to come up to. But that doesn't mean if you're not wearing a seatbelt that you will be contributory negligent. It does depend on the circumstances, such as in Chan Wing Kim. So if you're a pregnant lady, then not wearing a seatbelt, that might be reasonable for you not to wear a seatbelt. So the must-know cases: Ho Wing Cheung, Chan Wing Kim. Ho Wing Cheung on the standard of care for plaintiffs. Okay, remember the defendant's got to prove that the plaintiff did not come up to the requisite standard of care. Also, the defendant has to prove, we'll see this in a moment, causation. With regard to the standard of care, with regard to the other categories, remember the standard of care for infants is that of an infant of that ordinary infant of that age. Okay, remember those cases we looked at before, McCall and Watson and those other ones. Okay, so it does depend on the situation of who the plaintiff is in these particular instances, particularly with workers. The courts are always very sympathetic towards workers, a humane judicial attitude towards workers, particularly those working on construction sites in Hong Kong, and the courts will take into account the realities of the workplace. Don't worry about Sun Wan Co in just an illustration. So I think, though, the leading case, Ho Wing Chung, with regard to standard of care, and when it comes to contributory negligence, everybody, in exam questions, it's often a traffic accident where the plaintiff is not wearing a seatbelt. Okay, so there you are. So also with regard to the elderly, on page 132. The courts are very lenient on elderly people. So, you know, if you're an elderly person crossing the road, for example, and you fall over, then the courts are normally very sympathetic. Okay. All right, so that's the standard of care. As I say, Ho Wing Chung is your case, particularly with regard to seatbelts. A reasonable person would wear a seatbelt, so if you're not wearing it, then you don't come up to the requisite standard of care. But there may be circumstances, such as in Chang Wing Kin, in which it is reasonable not to wear a seatbelt. Okay. Also, the defendant will have to prove causation, and there's a must-know case here, everybody, and the must-know case is Wong So Ching on page 135. So highlight Wong So Ching on page 135. Wong So Ching and the official administrator. Remember, the defendant has to prove contributory negligence. That means the defendant has to prove that the plaintiff was at fault, didn't come up to the requisite standard of care, and also that there was causation. And in Wong So Ching, as it turned out, the defendant was unable to prove causation. So the defence of contributory negligence did not succeed in Wong So Ching because the defendant was unable to prove causation. So in Wong So Ching, the plaintiff was a passenger in a car. She was thrown from the car when the car ran into a hillside. She was not wearing a seatbelt. Okay, so you could argue didn't come up to the requisite standard of care, yes, but what about causation? In the Court of Appeal, the court found that the defendant had to prove not only that the plaintiff didn't come up to the required standard of care, but also that there was causation. And the evidence before the court showed that the injury suffered from the plaintiff could have been sustained either before or after she ejected from the car, or both. In other words, she would have suffered exactly the same damage even if she had been wearing a seatbelt. So in Wong So Ching, the defendant failed to prove causation. Therefore, the defence of contributory negligence did not succeed. Okay, all right. So that's the elements that the defendant has to prove. He's got to prove that the plaintiff didn't come up to the requisite standard of care. Ho Wing Chung is your leading case on the seatbelt cases. A reasonable person would wear a seatbelt if it was available. And if you don't wear a seatbelt, then you're below the standard of care. But also, the defendant will have to prove causation. And in Wong So Ching, the defendant was not able to prove causation, because even if the plaintiff had been wearing a seatbelt, the evidence was they would have suffered exactly the same injuries. Okay, all right. So let's get on now to apportionment, and this sort of comes to numbers, and I have adjusted this PowerPoint slightly. Wishing Long Hong. The amount of contributory negligence in Wishing Long Hong case was actually 20%. You may have in your particular PowerPoints 10%, but I've amended this. I think the correct figure is 20%. Now, we shouldn't get too carried away with numbers, but they are instructive. It gives us some idea of how the courts come up, what sort of numbers. But there is case law in which the courts in Hong Kong said there's little value in citing cases for the apportionment of liability on the individual facts of particular cases, because it's really up to it depends on the facts of a particular case. All right, but let's have a look at some ranges, and I think it is worth remembering the range of contributory negligence in seatbelt cases. Again, you can cite Ho Wing Cheung. So Ho Wing Cheung, very important case. Ho Wing Cheung gives us the standard of care with regard to seatbelts, and a reasonable plaintiff would wear a seatbelt if it is available. Okay. But Ho Wing Cheung also gives us the range that the courts will look at in deciding how much the damages will be reduced by for contributory negligence. And Ho Wing Cheung says that in seatbelt cases, the damages that the plaintiff can claim will be reduced by between 15 and 25%, depending on whether all or some of the damage was avoided. Okay, so if wearing a seatbelt would have prevented any damage at all, then your contributory negligence will be 25%. But if wearing a seatbelt would have reduced the severity of your damage, then you would only get 15%. So that's useful to remember, because in an exam question you would be advising somebody, and so it's nice to give a sort of a range, because remember, in any civil action, the two big questions: liability and quantum. How much money will the plaintiff get? So the plaintiff is very, very interested in how much money will I get, lawyer, okay? Well, you can pretty confidently predict that in seatbelt cases, assuming that the defendant is able, well, they would be able to prove, because in Hong Kong, a reasonable person would wear a seatbelt if it's available. So if the plaintiff was not wearing a seatbelt at the time of the case, and indeed there is causation, you've got to also remember proof causation. Well, how much will the damages be reduced by? Well, you can confidently tell your client between 15 or 25%, depending on the circumstances. If wearing a seatbelt would have prevented all injury, well, your damages will be reduced to 25%. If wearing a seatbelt would have reduced the severity of the injuries, well, they'll be reduced by 15%. So it's up to the court. The court can decide, okay? Remember Section 21 of LACO. Don't forget the wording, Section 21 of LACO, is that the damages shall be reduced to such an extent as the court thinks just and equitable, having regard to the claimant's share and responsibility for the damage. So it's really up to the court to decide what is just and equitable. Okay, but let's have a look at other cases. Wishing Long Hong is on page 136 again. And remember, in Wishing Long Hong, it was the hiker hiking along the mountain in mainland China. There were 6 employees, but only 3 torches. One of the employees, who did not have a torch, fell down and was killed. And so the personal representatives of the killed employee sued the employer. And there were 2 issues here. Was there breach of the duty of care? And the court said yes, because a reasonable employer would have provided better lighting. But was there contributory negligence in Wishing Long Hong? Well, the answer is the court said yes, because if you fall down, are you at fault? Usually, yes, okay, unless somebody pushes you over or something. So the court did find in Wishing Long Hong that the plaintiff was contributory negligent to the extent of 20%, okay? So, as I say, I've amended that figure. I think before I had 10%. But again, we shouldn't get too hung up on numbers, because the final decision is up to the court in a particular case. We've also noted in the Reeves case that if there is deliberate self-injury, such as suicide, then the relevant defence will be contributory negligence, and in Rees, the damages were reduced by 50%. Fair enough. Badger and the Ministry of Defence, back on page 136. Badger and the Ministry of Defence is a case close to my heart because my wife died and she was a very heavy smoker, and so I'm very anti-smoking. But anyway, let's have a look at Badger and the Ministry of Defence. I would suggest a must-know case. A widow's claim for damages for her husband's death from lung cancer after he was exposed to asbestos was reduced by 20%. So that's quite a big reduction. Why? Because her husband had contributed to his own death by refusing to give up smoking, which had also caused the lung cancer that killed him. Okay, so there you are. The claimant's husband worked for the Ministry of Defence as a boilermaker, was exposed to asbestos fibres. Remember, we looked at those cases like Fairchild before in the context of causation. Remember, asbestos fibres are very fine fibres that if they get into your lungs can cause a lot of damage, such as lung cancer. So in this particular case, the boilermaker was exposed to asbestos fibres in the course of his employment. He died at the age of 63 of lung cancer. He had received numerous warnings about the damage that his continued smoking was causing to his health, and had been advised to stop smoking on numerous occasions. There was no evidence that the victim was so addicted to tobacco that he could not reasonably have been expected to stop smoking. Interesting, because it is very difficult to give up smoking, because tobacco has a double hook. It wakes you up and also puts you to sleep. So it's twice as hard to quit smoking as it is to quit any other hard drug. Any other hard drug either lifts you up or drops you down, sort of thing. But the court did say, yeah, that's interesting, there was no evidence that the victim was so addicted to tobacco that he could not reasonably have been expected to have stopped smoking. So he was at fault, okay? So the court held that he had been guilty of a fault that was partly responsible for his death. A reasonably prudent person who had been warned there was a substantial risk that smoking would seriously damage his health would have stopped smoking. Okay, so there you are. This is the judgment of the court. And the principle of contributory negligence was that a person had responsibility for their actions, and the reduction in damages was just and equitable. And what it was had to take into account the relative blameworthiness of the party's conduct. So he was partially at fault by continuing to smoke. And the contribution to the combined risk of his continued smoking when he should have stopped was held in the region of half of his ultimate risk. The appropriate reduction was held to be 20%. Well, that's up to the court. Okay. So there you are, 20%. Because he failed to stop smoking and he was partially at fault. Okay. And then Nettleship and Weston. Remember Nettleship and Weston? The learner driver case. And remember, in the learner driver case, the learner driver was in an accident. Okay. Was there negligence? Yes. Remember, because did the learner driver owe duty of care to other road users? Yes, Donahue and Stevenson, Cheng and Wu. Was there breach of the duty of care? That was one of the issues in Nettleship and Weston, and the court said yes, because the standard of care for a car driver is that of a reasonably competent driver. And bad luck, learner driver, you will be judged by that standard. And so there was breach of the duty of care in Nettleship and Weston. There was causation and damage because the driving instructor was injured. So the driving instructor in Nettleship and Weston sued the learner driver. Right, okay, good. And the learner driver was negligent. The driving instructor was able to prove all the elements of negligence, but the learner driver raised the defence of contributory negligence. And when you think about it, yes, because the driving instructor is partially at fault because he should have been a better instructor, if you like. And the court, in its wisdom, it's really up to the court, decided to reduce the quantum of damages in Nettleship and Weston by 50%. Okay, so Nettleship and Weston, as I say, Wishing Long Hong and Nettleship and Weston are good cases because they are relevant to two big issues. They are both relevant to whether there's breach of the duty of care. Wishing Long Hong, it was breach of duty of care by an employer. Okay, and similarly in Nettleship and Weston, was there breach of duty of care by a car driver? Court said yes. Was there contributory negligence in Wishing Long Hong? The court said yes, 20%. Was there contributory negligence in Nettleship and Weston? The court said yes, 50%. The driving instructor was 50% contributory negligent. Okay, interesting one. All right, and then we have other cases dealing with how much will the damages be reduced. And one interesting case here is the Stapeley case. So I'm just checking my notes here. The Stapeley case, which is on page 136, I think. Where's Stapeley on? In Stapeley, there was quite a big reduction, 80% reduction in Stapeley on page 133. So Stapeley on page 133, the full citation, Stapeley and Gypsum Mines Limited. On page 133 again, Stapeley and another fellow worker, Dale, were employed to work in the employer's mine. They were instructed by the employer to remove a section of the roof of the mine for safety reasons. Well, this is dangerous work. They tried but did not succeed. Instead of getting help to remove the roof, Stapeley continued to work under the roof, but he should not have done that. He was killed when a large piece of roof fell on him. So his widow brought an action to claim compensation from the employer in negligence. All the elements of negligence were satisfied. Breach, was there duty of care owed by the employer? Yes. Was there breach? Yes. Causing damage? Yes. But was there the defence of contributory negligence? The court said yes. 80% contributory negligence in Stapeley, which is very, very high. Okay. Normally the courts don't grant such high numbers, but there's quite high in Stapeley. Also, another case here is Harrison on page 133. Harrison and the British Railway Board. The plaintiff was a guard who was injured when he tried to assist the defendant passenger getting on a moving train. So the guard at first tried to stop the train by signalling, but he used the wrong signal and the driver continued to accelerate. Oh, there, sounds like a movie, doesn't it? The plaintiff then tried to pull the passenger onto the moving train. Doing so, both the plaintiff and defendant fell out of the train, and the plaintiff too suffered injuries. And the court accepted that the passenger owed the guard a duty of care, but held that a reasonable guard in those circumstances would have applied the emergency brake instead. So was the guard at fault? Yes, partially at fault. He was sort of a rescuer, but the court rather reluctantly found he had contributed to the injuries he suffered. How much? 20%. So his damages were reduced 20% to reflect his contributory negligence. So there you are, a good list of cases there, but sort of a word of warning with regard to contributory negligence. If you go to page 137, there is a case there called Christopher Gordon Young, which I don't have on the PowerPoint. The top of page 137, Mr. Justice Yoon in the Court of Appeal. There is little value in citing cases for the apportionment of liability on the individual facts of those cases. An apportionment of liability is not an arithmetical calculation with one absolute answer. It's up to the court in a particular case. So all the cases on the screen are just by way of guidance, except perhaps you could argue Ho Wing Chung and the seatbelt case a bit more than just guidance. In there's sort of almost a tariff range between 15 and 25% reduction in the seatbelt cases. All right. So it's really up to the judge or the court in a particular case as to how much contributory negligence, how much the damages will be reduced for contributory negligence. Okay, so a good list there. I mean, stately is the exceptional one. That would not happen very often. So if you like, Harrison takes the cake. 80% is quite a big reduction. Okay, wishing long home, 20%. Okay, that's quite high, you know, because you're partially at fault if you fall down unless somebody pushes you or something. Reeves is quite high, 50% for deliberate self-injury, and Badger, I mean, smoking, if you like, 20%. And Nettleship and Weston, 50%. Okay, so there you are. So if you're advising somebody in an exam and the relevant defence is contributory negligence, unless it's a seatbelt case, then you can't say how much the damages will be reduced by. Is really up to the court on the facts of a particular case. And the case that's right up the top, sorry, the wording, sorry, right up the top, comes from section 21. The damages will be reduced as the court thinks is just and equitable, depending on the relative blameworthiness and causation. Okay, so everybody, even though these cases are interesting and even though the numbers are sort of instructive, if not final, don't forget section 21. Section 21 is the must-know source of law here, plus I would suggest Ho Wing Chung. Ho Wing Chung is must know on the standard of care, particularly for seatbelt cases. All right, and Ho Wing Chung is also good on the range for seatbelt cases. But in all other cases, how much the damages will be reduced by really depends on the facts of the case and is up to the court. Okay, all right, so a good list of cases there. Also, before we have our second break, well, actually, I've given you this new PowerPoint. Actually, this is a newer PowerPoint I came up with about the previous cases only being a guide, and that's from that case of Young and Lee on page 1. Where is it? On page 137. Yeah, Young and Lee. Yes, so it's Gordon Young. Christopher Gordon Young and Lee Chu, okay, from 2004, okay. There are little value in citing cases. Final reduction is up to the court on the facts of that particular case. And though, as I mentioned before, certainly the seatbelt cases, that range between 15 and 25%, okay. All right. So that's a new PowerPoint. I'm probably not in your bundle, so you might want to take a photo of it or whatever. Although these lectures are being recorded, aren't they? So I thought I'd throw this one in just to elaborate a little bit more on contributory negligence. Okay, everybody, I think it's probably a good time now to have our second 10-minute break. So after the break, I'll come back and just summarize the defences, and then I want to have an introductory look tonight at our next topic, which is going to be private nuisance. Okay, but let's have a break first, and then we'll come back after the break. So let me just put a little note in the chat box. Okay, welcome back everybody into the final stretch now, as I've just put in the chat box. So we'll be finishing off defences pretty quickly, and then I want to have an introductory look at private nuisance. And remember, private nuisance is the subject of question 2 in your assignment. And so I'm not sure when your assignment is due. Perhaps somebody could drop me a line saying when your assignment is due. And I will have a word about the assignment, not tonight, I'll have a word about that on Saturday. You know, what's expected of you in an assignment, well, from me that is, okay. So sort of common sense comments about your assignment. I'm not sure whether I actually mentioned that before or not, but I will talk about the assignment on Saturday. Question 1 you can already do. That's a question on formation of a contract, in particular the element of agreements, okay? And then question 2 is on private nuisance. So I want to start private nuisance a bit tonight. And so if somebody can tell me, what's the deadline for submitting your assignment, then that would be helpful too. But we will start on private nuisance tonight. Oh, there it is, 23rd. Oh my goodness, tons of time. 1 month to go. Thank you very much for that little note. Okay, but more on the assignment when we meet virtually on Saturday. Okay, so let's finish off contributory negligence. Perhaps it's probably worthwhile going through from the very top on contributory negligence. Remember, it's the plaintiff's failure to take reasonable care for his own safety. So the plaintiff has to be at fault. And the plaintiff's negligence is either a cause of the accident or causes a worsening of his injury or damage. So remember, the burden of proof will be on the defendant. The defendant has to prove contributory negligence. And he has to prove that the plaintiff was at fault, didn't come up to the requisite standard of care. Also has to prove causation. But the key source of law for contributory negligence is section 21 of LACO. It replaces the common law rule which says that even 1% contributory negligence was a total defence, which seemed very much unfair to the plaintiff. And so section 21 of LACO mimics the English legislation, and it means that, well, no better way of proceeding to have a look at actually section 21 itself on page 130. Where any person suffers damage as a result partly of his own fault. So the plaintiff has to be at fault and partly the fault of other person or persons. A claim in respect of that damage shall not be defeated by reason of the fault of that person suffering the damage. Okay. In other words, there will still be liability, what that means, but the damages recoverable shall be reduced. Key word is reduced. How much? To such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. Okay, so section 21 modelled after the equivalent English legislation. What do you mean by fault? Fault is defined to mean negligence or breach of statutory duty or other measure. What does that mean? There is actually a separate tort called breach of statutory duty. Did you know? And it's based on the wording in a statute. And the wording of a statute may impose some sort of duty on the defendant. And there is such a tort as breach of a statutory duty. We don't study it on our course. We only study negligence and nuisance. Okay, so that's what that's all about. Okie doke. So that's BSD. That's what, yeah, so I should explain that. BSD is breach of statutory duty. It's actually a tort, strangely enough, and it is sort of similar to negligence, but not the same, that's for sure. And indeed, there are certain facts which may give rise to both negligence and also breach of statutory duty. From the top of my head, there is wording in the employment ordinance in Hong Kong, and which imposes some sort of duty on an employer, and you can claim breach of that statutory duty. Okay, anyway, so section 21 of LACA, everybody can't emphasize strongly enough how important that is. Okay, and then getting on to the must-know cases, Ho Wing Chung must-know case, because it says the standard of care for a plaintiff is relevant, and a reasonable plaintiff would wear a seatbelt if it was available. But don't forget Chan Wing Kin. It doesn't mean if you're that you have to wear a seatbelt all the time. You can if you can claim special circumstances which warrant not wearing a seatbelt, then there may be no contributory negligence. Okay, and of course the standard of care that the plaintiff has to come up to will depend on who the plaintiff is in the circumstances. Okay. But also remember the defendant has to also it's getting late, has to prove causation. Wong So Ching is your case. In Wong So Ching, the plaintiff was not wearing a seatbelt. Was he at fault? Yes, but because a reasonable plaintiff would wear a seatbelt, but the defendant was unable to prove causation because the expert medical evidence showed that even if the plaintiff had been wearing a seatbelt, he would have suffered exactly the same injuries. Well, that's simply a matter of evidence before the court. So Wong So Ching, everybody, I would suggest is a must-know case, because the defendant must also prove that the plaintiff, that there was, causation. Okay. And then with regard to the actual reduction, the apportionment of the damages, it does depend on the court in a particular case because of the wording of section 21, which says that the damages shall be reduced as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. So I've got all these cases on the screen which are sort of interesting, yes, but this PowerPoint summarizes it probably quite neatly. All of those cases quite interesting, yes, but previous cases are only a guide, said Miss, I think she's a lady actually, I think it's Maria Yun, who's married to our previous Chief Justice, Jeffrey. Yeah, okay. Anyway, she says that the cases are only a guide, little value in citing cases, unless, of course, it's a seatbelt case. The final reduction is up to the court on the facts of a particular case, but with regard to seatbelt cases, Ho Wing Chung, again, you can cite that with a little bit of confidence. The court will follow that range between 15 and 25% in seatbelt cases. Okay, and remember the burden of proving any defence is on the defendant, so the defendant has to prove contributory negligence, and you would have to prove first of all fault, that the plaintiff didn't come up to the required standard of care, is at fault, and also has to prove causation, all on the balance of probabilities. Okay, now just to finish off defences, I've thrown this one in. This is, I'm not sure if it's actually in your course manual, or probably mentioned briefly here, but it's worthwhile noting that you could argue that there is a defence that a defendant could rely on, and that is lapse of time under the limitation ordinance. And you should appreciate that under the limitation ordinance, the general rule for tort actions is 6 years from the date of the accident. But don't forget, if it's a personal injury, the limitation period is only 3 years. Okay. There are other provisions dealing with situations in which the damage is not clear at the start, so-called latent damages cases, which the time period is 6 years plus 3, and absolute maximum of up to 15 years, covered in sections 31 and 32 of the limitation ordinance. Should know, not must know. I think the only must know period is for personal injuries, because in exam questions it's normally a personal injury case. The time period under the limitation ordinance is 3 years from the date of the accident, or 3 years from when any injury was reasonably discoverable. Okay, so worthwhile bearing in mind, you could earn 1 or 2 extra marks if you can raise this in an examination answer, if it is relevant, okay? Also, section 30 of the limitation ordinance is worth noting, that the court can override any of these time limits. So the courts are normally quite generous to a plaintiff when it comes to the limitation periods under the limitation ordinance. Okay, everybody, so that's all the defences. So what I want to do tonight, by way of introduction, is to have a look at private nuisance, because it's what is relevant to question 2 in your assignment, which is due, I'm told, by 23rd of March 2021. By the way, everybody, you can do question 1 now, and I suggest you do question 1 now, because that's the one on formation of a contract. Particularly, remember, the only element at issue in question 1 of your assignment is the element of agreements. Okay, remember how you start off question 1 in your assignment. I'm not sure what the name of the parties were, but so-and-so would like to know if there's a contract between him and the other person, whoever that is, full stop. And then the court will look for essential elements in the formation of a contract, colon, you know what they are, agreement, consideration, intention, etc., full stop. Next sentence, the only element in issue in your question 1 of the assignment will be the element of agreement, full stop. You know the next sentence, the courts will analyse the existence of agreement in terms of offer and acceptance unless there are exceptional circumstances. House of Lords, Gibson and Manchester City Council. Next sentence, there will be no exceptional circumstances in your question 1 of the assignment. So then to finish off your answer, you have those headings which I gave you in answering questions where agreement is the element at issue. First of all, is there an offer? Has it been communicated to the offeree? Is there acceptance? Has acceptance been communicated to the offerer, or has the offer been revoked before acceptance? Okay, and then it's up to you to follow that guideline, and question 1 should not be too much of a burden, I hope. Question 2, though, is on private nuisance, so this is what I want to start off on now. So let me just set up the PowerPoints first. Where are you? Where is private dispute? I can't see because it's so small. Where is private nuisance? What number are you? Oh, no, okay, not you. No, actually, they're down the bottom, aren't they? Let me see if I can get it this way. Yes, there you are. Okay, private nuisance. Well done. Okay, everybody, so this is our second major tort on the course. Nuisance in general. There are actually 2 types of nuisance. One is private nuisance, and the other one is public nuisance. Public nuisance, less important, but important nonetheless, and we will be working through public nuisance. Public nuisance is important from your point of view in that you may be asked a question in the exam comparing and contrasting private nuisance with public nuisance, okay? But the more important tort is private nuisance, okay? So this is what we're going to talk about for the rest of tonight, and we'll finish it off on Saturday. So let's have a look first of all, and is there a definition of private nuisance? Yes, there is. Your course manual doesn't exactly say it as I've got it on the screen, but everybody make sure you know that private nuisance is unreasonable interference with the use and enjoyment of the plaintiff's land. Emphasize the word land, okay? And it's important to note, and we'll note this shortly, the only persons who can sue in private nuisance are those people who own land, okay? So this is why I put in bold print the word land. It's the effect on the plaintiff's land which is important. So the plaintiff must own land. So to a certain extent, you need to have a knowledge of land law. For example, hang on, I've got another one. Dear Mr. Sir, would you provide a face-to-face extra assignment class before the end of February? No. I'll talk about the assignment on Saturday, and I'll give you all you need to know about question 2. You already know about question 1. Question 1, you can nail it, okay? Question 2, it's not difficult either, you'll find, as we go through. So don't worry about the assignment, okay? And we will finish off private nuisance when we meet again on Saturday, and then you'll be in a really good position to finish off the assignment, which is going to be a good month before the deadline, which is 23rd of March. Okay, so there you are. That's with regard to the assignment. All right, so there is, your course manual doesn't actually put down a definition of private nuisance, which is a bit of a shame, because you can define it as I've got it at the top of the screen, and write this down in your must-know definitions. Add it to vicarious liability. Okay, unreasonable interference. Sorry, private nuisance is unreasonable interference with the plaintiff's use and enjoyment of land. Full stop. That would be it. I've also got by neighbouring land users, but normally that's a given. Okay, so the focus is on the effect on the plaintiff. Okay, and his land. Okay. Now, of course, we've got some vague wording there. What do you mean by unreasonable? Okay. Well, again, it's going to be up to the court. What is unreasonable does depend on the effect on the land. If it's what we call intangible interference, then there will be a variety of factors the court will look at to decide whether the interference is unreasonable. If there's actually physical damage to the plaintiff's land, though, that is unreasonable without any extra analysis. Okay, so that's the third bullet point on the screen. So watch out for that in your assignment question 2. If there's actual physical damage to the plaintiff's land, that will be unreasonable interference without any further analysis. Okay. And the case I've got on the screen is called St. Helens Smelting and Tipping, which is an English case, not in your course manual, but there is a Hong Kong case called ACL and Bulmer, B-U-L-M-E-R, on page 97, which says the same thing. Okay, so I like the case name, St. Helens Smelting and Tipping. It sort of slips off the tongue quite nicely. All right. So how do you know whether the interference is unreasonable? Well, if it's intangible interference, then the court will have to look at a range of factors. And what types of things might amount to nuisance? Well, it can be noise, yes, smells, durians, etc., dried fish, I don't know. Smoke is a common form of nuisance, vibrations, etc., as well as physical damage, okay? But as I say, I emphasize, when you're looking at private nuisance, look at the damage suffered to the plaintiff's land. If there's actually physical damage to the land, that is unreasonable interference, full stop. If it's less tangible interference, then the court will look at a range of factors, which we're going to look at in a moment, okay? And this will depend on the facts of each case. They'll look at the nature of the interference, the extent of the interference. Timing in particular is important. Now, I'm not sure, you people who are at home at the moment, will you be taking a shower later? Good question. Well, if you do, bear in mind a case called Capital, Prosperous and Sheen. And Capital, Prosperous and Sheen is on page 100 of the course manual. Actually, it's misspelled. It says Capital Properties. Actually, it should be Capital Prosperous. Okay. So my PowerPoint is correct. And the Capital Prosperous case does actually, I think the course manual mentions it elsewhere, and they got the spelling right. But the correct name is Capital Prosperous, as indeed a prosperous year of the ox, you could argue. So Capital prosperous is the correct case. And let's see if I've got it. Have they got it? So I'm just checking a little bit here. I think it's actually mentioned in your... Oh, there it is. Yeah, they got it right. On page 95, you've got capital prosperous and she. Well done. And they've correctly spelt it. But on page 96, sorry, not 96, on page 100, capital properties should be capital prosperous. Capital prosperous and sheen, good case. Somebody is having a shower at night time, and in a multi-story building in Hong Kong, it's common for there to be a water pump, which pumps the water up to the 20th floor or whatever it is, okay? And what happened was that one person, I think on the 19th floor, was in the habit of going to bed early because they had to get up very early the next morning. But their neighbour above them on the 20th floor was in the habit of having a shower late at night, okay? And the noise from their water pump was such that the plaintiff couldn't get to sleep. So they sued their neighbour in private nuisance. So, was this unreasonable interference? And the court looked at a range of factors, particularly the timing of the interference. And they decided, was this unreasonable interference? And the court said it was not unreasonable timing. Why not? Because Hong Kong people go to bed late and they have showers late. And I'm going to have a shower when I go home tonight. Very short one, just to wash my feet, etc. I don't think my water pump's making unnecessary noise, but this is what happened in capital prosperous and sheen. So next time you're having a shower, say to yourself, reminds me of this case. Capital prosperous and sheen, operating a water pump, I think it was about midnight, was not an unreasonable time to have a shower. Okay, all right. So capital prosperous and sheen, everybody, will be a must-know case. So there you are. That's one case that should be easy to remember. But also, the ACL and Bulmer case is a must-know case as well. We'll be looking at that. Bulmer's on page 97. Physical damage to the plaintiff's land is unreasonable interference. Full stop. Okay? But less tangible interference, it's really going to be up to the court on the facts of a case to decide whether the interference is unreasonable. And the next PowerPoint does illustrate some of these points. What is unreasonable use? Well, as I say, if there's actually material damage, physical damage to the plaintiff's land, St. Helens Smelting and Tipping plus Bulmer says that is unreasonable, full stop. Okay, so in your assignment, question 2, look at the interference to the plaintiff's land. Is it actually physical or material damage to the plaintiff's land? Then that will be unreasonable interference. But what about the less tangible interference? Well, this is where the court will look at various factors. Timing and duration, well, that's capital prosperous and sheen. Remember, the court said having a shower at night time is not unreasonable time, because Hong Kong people go to bed late, okay? Also, with regard to reasonable user, there's quite a good material on page 98. There's a bit of a summary there with the factors, environmental factors of the locality, timing, duration, and frequency. Well, that's capital prosperous and sheen. Locality obviously is important. What might be a nuisance in a very upmarket part of Hong Kong may not be a nuisance in other parts of Hong Kong. Are you in a residential area or is it a commercial area, whatever? So locality is important. The so-called locality principle comes from an English case called Sturgis and Bridgman on page 99, in which Passenger, Lord Justice, does come up with that quote, similar to what I've just said. Whether anything is a nuisance or not is a question to be determined not merely by an abstract consideration of the thing itself, but in reference to the circumstances. where what would be a nuisance in Belgrade Square, well, let's put that the peak, say, in Hong Kong, would not necessarily be so in Vermont, I don't know, a less salubrious part of Hong Kong. Okay. So in Hong Kong, what would be a nuisance in a low-rise residential area on the peak? Oh, it actually mentions peak. Would not be a nuisance in an industrial area in Tsuen Wan. So apologies if you live in Tsuen Wan. But Tsuen Wan's become gentrified, isn't it? So locality is important, the locality principle. But there are limits. Even if you're in a commercial area, there can still be nuisance. And the Realty Harvest case on page 99 is a good example of that, where there was excessive noise and vibrations. The court found that that was still unreasonable, even though it's in an industrial area. Okay, so in Realty Harvest on page 99, the plaintiffs and defendants were owners and tenants of an industrial building in Tsuen Wan. Plaintiffs brought a claim against the defendant in nuisance for noise and vibrations caused by the weaving machinery. Both the plaintiffs and defendant had installed noise insulation material, but that did not help. So at trial, the plaintiffs adduced expert evidence, and indeed the court will rely on expert evidence in a lot of these cases, to prove that the noise and vibration levels exceeded acceptable British standards, assuming Hong Kong standards as well. So the defendant argued that because the building and its surroundings were noisy, the particular noises and vibrations arising from the operation of its machines should not be regarded as exceeding the reasonably acceptable level. So the court said that that was unreasonable interference. It was excessive noise and vibrations, unreasonable, even though it's in an industrial area. It is a question of degree with reference to the facts of each case. So, Realty Harvest, good case on page 99. Okay, also a slightly tricky one, this area of malice, the defendant's response to the plaintiff's behaviour. A couple of cases here on page 100. First of all, Christie and Davey. Because if the conduct was triggered by malicious intention, the court will more easily find the conduct amounting to nuisance. So in Christie and Davey, the plaintiff was a piano teacher, oh my goodness, chopsticks and all that, who gave piano lessons at her house. The defendant was her neighbour, who found the noise during these lessons annoying. Yes, well, it can be. All right. I'm not sure what other instruments. I mean, in Hong Kong, you know, music's good. Saxophones, pianos, I don't know what, guitars, who knows. Anyway, it's a piano teacher giving piano lessons at her house. The defendant was her neighbour, found the noise annoying. In order to express his displeasure, the defendant deliberately created noise in retaliation. Okay, so the plaintiff sued the defendant for nuisance, entering judgment in favour of the plaintiff. The judge held what was done by the defendant was done only for the purposes of annoyance, and in my opinion was not a legitimate use of the defendant's house. So you can't react in such a way which is malicious. That could be private nuisance. What is the remedy for private nuisance? The answer, everybody, will be an injunction. That's the most common remedy for nuisance. It will be an injunction to stop that particular behaviour happening. Similarly, in Hollywood, Silver Fox Farm and Emmett, the plaintiff bred silver foxes on a farm. During mating season, the foxes were very sensitive to noise, so here we got a fox hater. The defendant was the owner of the neighbouring land. Out of malice, he fired guns on his own land near the boundary with the plaintiff's farm. As a result, the silver foxes refused to breed, miscarried or killed their cubs. That's nasty. The court granted an injunction. So there you are, that's the remedy, an injunction preventing the defendant's otherwise legitimate conduct. It was legitimate to fire the guns, I guess you could say, but this was out of malice. Okay. All right, so that's Hollywood, Silver Fox Farms and Emmett. Okay. I've got a case there of Chan and Thomas on page 101, another one. Plaintiff and defendants were owners and occupants of neighbouring houses in Clearwater Bay. Okay, Water flooded his house. The defendant inserted a grill in a drainage channel at the rear of the house to block debris from entering the channel so as to prevent further flooding in his house. The action, however, increased the risk that the flooding would be diverted to the plaintiff's house. The drainage channel at the rear of the plaintiff's house became blocked. Foul-smelling floodwaters entered the plaintiff's house at the first floor level. Sounds very nasty. Ran down the stairs to the ground floor level, caused considerable damage to the premises and furnishings. So the plaintiff argued the blockage was caused by the grill inserted by the defendant. This created a nuisance. Okay, so the court did not specifically find malice. It did find, as a matter of fact, that the plain intention of the defendant in placing the grill and the consequences of the behaviour was to move the risk of the flood from its property onto his plaintiff's property. Court found such behaviour impossible to justify and unreasonable. Okay, so that was unreasonable. And just to go out with tonight, one more case, which is a must-know case, and indeed abnormal sensitivity. You could put the Capital, Prosperous and Sheen case in this category as well, because Capital, Prosperous and Sheen, you could argue, is that the plaintiff had abnormal sensitivity. Okay, and in that most people in Hong Kong go to bed late. They don't go to bed at 8:30 or something. But Robinson and Kilvert is the leading case on abnormal sensitivity. Just remember, the issue here is this unreasonable interference? And in Robinson and Kilvert, the plaintiff occupied the upper floor, the defendant occupied the lower floor. The defendant operated a business that required hot, dry air. It was in the photographic business. And as a result, the temperature of the floor of the plaintiff's premises was above 80 degrees Fahrenheit. The plaintiff stored heat-sensitive paper. Heat-sensitive paper. And the heat-sensitive paper was damaged from the extra heat. But that extra heat would not have affected ordinary paper. And so this was not unreasonable interference, because ordinary paper would not have been affected by the heat. The fact that it was heat-sensitive paper, bad luck, you're abnormally sensitive, and so that was not unreasonable interference in Robinson and Kilvert. Another situation might be, let's say somebody is a nurse who is working at a hospital and they work at night time and sleep during the daytime. Well, the nurse cannot complain about noises which emanate normally during the daytime, like somebody drilling next door, for example, because you will be judged from the standard of an ordinary plaintiff, normal plaintiff, not somebody who is abnormally sensitive. Okay, so there you are. If you're going to have a shower later on tonight, I hope you can do so quietly, but if you do so at a reasonable time, so I'd say any time up to midnight, that would be a reasonable time. Don't worry, you would not be sued in nuisance. Okay, so they are Capital, Prosperous and Sheen, the shower case, you could call it. Okay, but Robinson and Kilvert is a must-know case as well. That's the heat-sensitive paper case. All right, so that's it for tonight, everybody. We will finish off private nuisance next time we meet on Saturday. I will make further comments about the assignment on Saturday, and after Saturday, you'll be able to do question 2 in the assignment. I'll also make specific comments about some of the requirements in the assignment, sort of common sense type ones, you know, like start each question on a new page, single space your answers generally, no need for footnotes or bibliography, that type of thing. So I will talk specifically about the assignment on Saturday, and I will, after Saturday, you could probably do both questions, and Saturday's what? Saturday's actually the 20th, isn't it? And so the assignment's not due to 23rd of March, so you'll have plenty of time to do the assignment. Okay, good. All right, so that's it for tonight. Thank you very much for your attention. Kungi Fat Choi again. Let's hope the year of the ox is much better than the year of the rat, which was really a ratty type year, wasn't it? Anyway, my goodness. And I hope we can get back to face-to-face. Certainly we'll be able to do so, I think, after March, certainly for the revision classes, we will hopefully be face-to-face and get you ready for the exam. And if you listen to what I say during the revision course, you'll have no problem with the exam. Okay, but of course, you know already how to do well with the exam. Know your must-know definitions, must-know principles, must-know cases. All right, so that's it for tonight, and sleep well after your shower, your quiet shower, yes, and I'll see you on Saturday.